Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, Managing Partner and CEO of Cordell Cordell. And in our virtual town halls, we continue to bring you a panel of Cordell Cordell attorneys. And today is no different, but the topic is different. Divorce, modifications, contempts, anything involving family law. We know you have questions. And sometimes just talking about a topic of the law, talking about the law specifically in general, it's not enough. In other town halls, if you've been or attended some of them or watched them on our YouTube channel, we always reserve some time to take questions. But today for 30 minutes, it's all about you to answer your questions. We already have some questions submitted, and we'd love to hear from you today. So submit those in the Q&A section. If you have questions, we know you have them. Go ahead and submit them now in the Q&A section. Just give us the question along with your first name and the state in which you are, and then maybe with the panel that we have today, the two litigation partners that we have, we can try to get you some direction. Always keep in mind that the danger with a question and answer session is we cannot give you legal advice here in this small, shortened format. The best place, and really the only place for that, is a consultation, a one-on-one. It can be like this, via Zoom, Teams, WebEx. It can be on the phone, or it can be in person. We have offices around the country in many cities, including the United Kingdom, near you. You can find out more information by going to cordellcordell.com. Right on that homepage, top right corner, you can schedule a consultation online. Don't even have to pick up the phone. You can do that across the country now. So check us out at cordellcordell.com. Again, Q&A section, you want to drop those questions in now. So before we get rolling, I want to introduce our panel, give them a few seconds to introduce themselves. From Texas, litigation partner, Kelly Burris.
Hi, Scott. Thank you for having me. I'm Kelly Burris. I'm a litigation partner in Austin, Texas. I'm board certified out here, and I've been practicing family law for 22 years now. So long time.
Great. Thanks, Kelly. And then again, both of these panelists have been repeat and frequent guests, and Jonathan is no different over in Utah. Welcome, Jonathan Winn.
Thank you. Happy to be back here doing this panel. I've been practicing at Cordell close to 12 years at Cordell and 17 years total as family law practice. So hopefully we can answer your questions today.
Thanks, Jonathan. Yeah, it's one of the things when we were thinking about a topic for August was we get a lot of questions, and certainly in consultations, we know you have questions. I was thinking about anything, whether I've often referred to medical issues. What do? You Google, you just want to ask a question. You want some direction. That's what this is for. It's educational, informational. Hopefully we'll lead you down the right path. So again, submit those questions in the Q&A section now. First name, give me a state, city, and then we'll try to lead you. So before we get to the questions, we have some already. Just a real quick break. We'll be right back after this.
Family moments matter, even when they don't go as you planned. Cordell and Cordell is a champion for fathers' rights. Kids count on fathers. Fathers can count on us.
All right, welcome back. So, okay, let's get right to it. We have 25 minutes. We can go through a bunch of questions. We have around 8 questions submitted already. Don't forget, if you're online, let's submit those. We'll get right to them. Let's start. Kelly, Tom has a question, and I can tell you it is a frequent question, and it's always when, especially in times now when we have inflation and perhaps recession, cash flow is an issue. Tom wants to know, can he cash out his 401k to use for attorney's fees and not get in trouble? So it's a multiple part question that we can focus really on the family law part. Obviously, there's the whole IRS rules in terms of penalties and withdrawal and whether or not you can withdraw without penalty. We won't necessarily get into those. But let's talk about, from your experience in the court system in Texas, what can or can't you do? Are there standing orders? What generally is allowed with regards to using your 401k?
Okay, well, it really is somewhat a state by state and to some extent a judge by judge answer to the question. So with that said, everything I'm going to tell you, check in your state with your judge, with your particular court, because I know some courts are more lenient with these types of issues than others. So in Texas, a lot of what we have in a lot of state courts is once a petition for divorce is filed, what goes into place is called a standing court order. And that standing court order I call it sort of a good behavior order. So what it does is it immediately goes into place against anybody and all the parties to the suit who've been served And it says, this is what you can do. This is what you can't do. And part of that is that you can't spend money for anything other than what is approved in this order by the court. And in that, it will say for attorney's fees and regular living expenses. So usually that is something that if there are no other funds, there's no liquid cash available, that I do have my clients can go into retirement accounts to get loans from the retirement account or liquidate accounts for purposes of attorney's fees. Now, that's, I say that, but also you also have to look at not just, is it a violation of a court order or not a violation of a court order, but you also have to look at how it's going to look in court. So sometimes we have these issues where I'll tell my clients, like, look, you're not under a court order to not do this. Okay. You're fine. You're not going to be held in contempt, but what is it going to look like from the judge? So if you go in and you liquidate the account and you put, $100,000 in attorney's fees in with your attorney to try to kind of protect that money, I mean, that's going to probably look pretty bad, even if it is legal in your state, or even if it is legal with your court. It's maybe something that it's just strategically not a good move. But it just depends on your court. So usually yes, but you just have to think about also those strategic issues.
Yeah. I mean, there have been moments, and I'm curious, where the spouse is unemployed and both of them have fees. They don't have the cash flow. And I've gone into, and I'm curious, Jonathan, even Kelly again, where we do a consent order where we say, okay, we're going to go ahead and withdraw 50,000. Each party gets 25 for the sole and exclusive purpose of paying attorney's fees. Obviously, consent with the, order of court. Obviously, that's something that's been done before.
That was exactly where I was kind of headed, Scott, is typically if both spouses are agreeing on the withdrawal, the court's okay with it.
Mm-hmm.
It's when one spouse unilaterally does something or even makes it look kind of sneaky or underhanded, that's really going to come back to bite you. So if you're open and you just tell your wife, hey, look, it looks like we're going to, or spouse, you say, hey, we're going to have some money for this. How much do you think you need? Okay, let's just match that and make an equal amount to each of you. A couple of tricks on that is, again, you got the tax issues. Are we going to do it as a loan? That kind of helps with the taxes. There's not penalties. If you do it as a withdrawal, or maybe you're at the age where you can do withdrawals, then what are we going to do with the taxes? Are we going to withhold the taxes first with the idea that we're going to withhold them because maybe later you're divorced, and who knows if it's your 401k and you get divorced before taxes are paid, you're paying all the taxes, even though you gave her half the money.
Yep.
So you want to make those considerations ahead of time. As like you mentioned from the very beginning, the IRS has a lot of laws there that we want to be careful with.
Yeah. And it's a great example with anything. I've always said, decisions, things that you do always have consequences, good, bad, indifferent. It's a great reason to have a consultation, sit down, even if you're not in the middle of a divorce, not ready to file for divorce, but anticipatory. It's pre-planning, and it's making sure it's like doing your estate planning. You may not be sick, dying, just take care of things and just plan for it. So, all right, let's go to Jonathan. Tim wants to know if we have a template for working out income needs, wants to make sure he considers everything when he discusses finances. And I'm assuming maybe he's referring to like a statement of income and expenses, something that kind of aligns or outlines really what you have, and then maybe looking at child support and alimony and what is needed kind of thing, right?
Yeah. And Tim, that's a great question for a couple of reasons. Number one is you really want to be thorough in telling the court all of your income. You don't want to forget something and then have the court make it seem like you were purposely hiding income or you're trying to hide it under the table. And so making sure you've covered everything is very important. Then the other side is you're also doing the same on the spouse. You want to make sure you're accounting for whatever income they have. And so in my office, we actually use a state form. We call it a financial declaration. I know each state kind of has a different word for it that really does kind of take income and it broadens it and says, okay, what about gifts? What about money from parents or family? What about Social Security or any state benefits? And they go through business income and retirement income. And it does kind of break it down. And I think most states will have kind of that form. It is a state by state answer to that, but most attorneys will have their own form if the state doesn't have it already.
Yeah, there's a lot online. You can go to Men's Divorce, Dad's Divorce, Cordell. You can Google it. You're going to find out a number of resources that'll help you understand and outline your income needs, what the other person needs. But again, consultation gets you the right guidance as well. All right, Kelly, next up. How long should I wait before I pursue legal action if my ex-wife fails to remit me the terms of the alimony pursuant to the settlement agreement? I'd like to do it as soon as possible, as the alimony will be used for medical premiums. Could I have my ex-wife's wages garnished for alimony?
First of all, again, state law depends, but if you do have a mediated settlement agreement or some type of settlement agreement, and that has not been converted to an order, I would suggest prioritizing that being converted to a decree or a signed court order. For most courts, a court order is going to be much more enforceable, and potentially if it's an alimony or child support payment, it can be enforceable by criminal contempt. If it is a court order. If it's just a settlement agreement, it's potentially only a contract. And so while you might be able to get a judgment or something like that based on a settlement agreement, you may not be able to get the availability of possible contempt and possible enforcement may not be totally available to you if it's just a signed settlement agreement by the parties and it's not a signed order by the judge. So the first thing I'm going to say is I think making sure that goes into an order is going to be the best thing before trying to do enforcement proceedings. If that's not something that can wait, I mean, you can certainly try to get an enforcement through the court, sort of some type of contractual enforcement. Once it's court ordered, once you have an order from the court that's signed by the judge, usually for most maintenance and alimony child support, if it's more than 30 days past due, you can go after it. So you can file an enforcement if it's more than 30 days past due. At least that's in Texas. Some states may be different. So that's why I was saying it may be a case-by-case situation. So I don't want to say in your state, there may be some other type of timeline. But yeah, Texas is 30 days. And after that, as long as you have a court order, you can go after it.
Yeah. Here in Missouri, I've gone and done not only garnishments of wages, but also attached bank accounts. I've gone to seize property. You mentioned that 30-day limit. For us, it's spousal support. Although maybe it's due on the first of each month, it's technically not late until 31 days, the 31st day. So if you don't have a wage assignment already in place, you need to wait until it's late in order to do a wage assignment or to garnish or to attach. I think that's probably the first step I would take is hire a lawyer, go file a garnishment or an execution on bank accounts. If there's a large lump sum here in Missouri, each support payment is a judgment of itself, carrying 9% interest on the child support, for example. So again, it's probably worth a consultation. Get a strategy. What can you do? What should you do in place without necessarily going back to court, which is obviously the more expensive route. But typically in many states, there are statutes on the books that indicate that if you prevail in a contempt and it's due to support, the opposing party shall pay fees, but again, state to state issue. So, but good question. It's always, enforcement's always an issue. So, all right, Jonathan, next question from Illinois. I have proof that my ex-spouse is using my child support payments for personal use instead of on our son's expenses. What can I do?
Okay, great question. When you're looking at child support, first of all, when you're looking at the big support and understand, a lot of times we call child support is the money they pay you. It also could be benefits to health insurance, paying medical expenses, or even daycare expenses. That all could be kind of sometimes called child support. But in this particular case, I'm presuming it's the actual dollar amount that's being paid as a child support order. So the way it works really is you pay the child support amount, and with that amount, they're going to cover room, housing, school fees, school lunch, maybe paying for soccer, paying for football, buying a new backpack and a new pair of shoes. The court's not going to go through and try to earmark dollar for dollar which dollar went to buy her cappuccino and which dollar went to buy the pair of shoes. And it's almost impossible for the court to do that. So typically what the court's going to look at more is, are the child's needs being met? Is the child getting new shoes for school? Or is she coming to you and saying, well, I want child support, but now I also want you to pay for this and pay for this and pay for this. And the answer there, so rather than saying, hey, I want a dollar for dollar accounting, the answer is, well, look, this is what child support's supposed to cover. Like the purpose of the child support is to buy the new shoes. Now, again, every order might be a little different. If you've got an order that says you, and this also sometimes is determined by how much custody you have. Usually the higher custody, the more overnights and time with your child, the less your child support is, but the higher obligation you have to cover your half of the expenses. So in that scenario, maybe you are paying half a school lunch and half of school fees and half of extracurricular fees. On the other side, if she has, you have less time and you're paying more child support, you have a situation where, she's going to be covering those expenses. And so really the only recourse you have is just making sure that you're not double paying. You're not paying the child support and then also paying for things that the child support is supposed to be covering.
Yeah, there is, and I want Kelly's perspective from Texas, but I know in Missouri, it's interesting. There is a statute that is not widely used, and it's a very old statute that requires the recipient of child support payments to account and detail the use of those child support payments. And I mean, 20 years ago, I filed a motion to try to get the opposing party to do that. Judge had no idea what the statute was. I can tell you that many people don't. It's just kind of one of those archaic old statutes out there. But I think what Jonathan's saying is obviously, yeah, it's not intended to create a vacation fund or a retirement account or savings account or to buy smokes or a Cadillac. It isn't designed to do so. What I often like to do is find other reasons to file a motion to modify and then bring that up in discovery and find out where the money's going, use it as a reason to either decrease the support, and then you can use that extra decrease to pay for the things that she wasn't. So I think it's one of those things, again, is to kind of sit down and figure out what your state particularly provides as a remedy to account for how the support's being used. But Kelly, what are you seeing in Texas?
Yeah, I mean, we have a we have a guideline child support amount that's just going to get put into place. It's a percentage of net income of the obligor based on how many children are before the court. However, the court does say if somebody is seeking more than the cap maintenance. So there's there's a cap to that percentage amount. So it's whatever your percentage is times 9,200 a month. So if you net more than 9,200 a month, the other party has to show that the proven needs of the child exceed that. So the court, basically the legislature has found that anything underneath that is reasonable and you can't dictate how that's going to be used or what that's going to be for. But anything above that, then the obligee has to come and say, hey, this is why this child's needs exceed that. Additionally, Texas is a little bit more ours is 18. After they are 18 and graduate from college, that's it. And the guideline support is Jonathan mentioned, is supposed to cover all of those expenses. So when I have clients come in with those questions, I ask them, are you paying for things that, for this child that you don't need to be paying for? Like, are you paying extracurriculars? Are you paying on these other things in addition to the support? And if you are, stop, because that's what that support is supposed to be for. So we don't have anything like what Scott was mentioning, where you can require that the other side, other than, interrogatories or regular discovery that we might do in a case, but there's nothing that makes them prove what they're spending it on, absent them wanting more than cap maintenance or support, I should say.
And I think one of the follow-up would be, or the takeaway is, for example, if the child's not getting clothes, school books, school supplies, whatever it is, shoes, the normal basic necessities, fire off an email, record it and saying, hey, look, he keeps coming to me asking for shoes and says, you're not buying them. This is something that you should be purchasing with the child support. Kind of record it, put it in time and build your case over time to show, hopefully you're inviting her to fire back and says, nope, I don't care. You're going to buy everything and I'm just going to use it for my vacation in Cancun. For me, it's about, I don't want it to be a he said, she said. I want to make sure that we're recording it via, and confirming it in emails that we can show later in proof. So, all right. Mark has a question and I'll leave it to either one of you. What are things I can do when my soon to be ex is dragging out the process and making me spend unnecessary money on support and legal fees? Who wants it?
I can jump in first on here. So Mr. Cordell himself wrote a book years ago called the 10 Stupid Mistakes Men Make in a Divorce. And And honestly, if you look at those 10 issues, 5 out of 10 of them probably answer this question. But one I want to focus on is he talks about, I think it's mistake number 3 is waiting for your wife. In that particular case is waiting for your wife to file. But the intent of this is the difference between reactive litigation and proactive litigation. And one of the things we really try to do here is proactive litigation. It's not waiting for her to do something and then reacting to that, waiting for them to send out discovery and then saying, oh gosh, maybe we should do that too. Waiting for them to file a motion, then file your counter. It's really taking the time in the very beginning of the case, every week, every day, to say, what can I do to move this case forward? What can I do to get this closer to resolution faster, to find peace for this family? And that's an important part. And it really comes down to litigation strategy is probably the number one way to move a case forward. It's the attorney taking that time every day to think about how that case can get moved forward. Because if you don't, what ends up happening, I think, is the attorneys end up just answering emails and they just put out the fires that are in front of them and they don't think about long-term plans. So the litigation strategy, I think, is the number one way to get these cases done quickly and fast. And what that does is it actually decreases the cost of those cases significantly by pushing them through.
Kelly?
Yeah, I mean, I think this is also one of those discussions that you need to have with the attorney that, that's representing you, and making sure that you know what they can do to push the case forward and what they may not be doing to push the case forward and why they may not be doing it. So, in Texas, one of my things that I like to do to push cases forward is I put a motion for scheduling order, or what's called a discovery control plan in a lot of states. So basically I get an order from the court that says, hey, here's the deadlines here. We're going to set trial for this date. We're going to have mediation by this date, and we're going to do all these things. And that pushes everybody to move the case forward and have certain deadlines. And so it's not just sitting there and, someone goes on vacation and then we just don't get around and it's 3 weeks. And now we're having to reschedule some mediation because now those dates are old. So it just really kind of lights a fire under everyone to push a case forward if you have a trial date. And there's ways to get trial dates set. So like I said, file a motion with the court to make sure the court is setting it, or whatever that is in your jurisdiction. But a lot of the times, attorneys will just slow walk cases. And I will say it's sometimes easier to delay than it is to make a court move forward. And we are, as attorneys, dealing with, we're dealing with the court's schedule. So, I have some courts that I can get a final trial set under in 45 to 60 days, which is, we have to have at least 45 days notice in Texas. And then there are other courts where they're setting trial dates 6 months out. So it does kind of depend on your court, but your attorney should know what judge you're in front of, what court you're in front of, and have an idea as to the court coordinators and how that judge sets cases and how long out they will need to set a trial, to kind of look forward into the future to make sure that they're pushing those cases efficiently and sufficiently. But yeah, I echo what Jonathan said. It's about proactive litigation and not just sitting and kind of putting out fires. So you want to be sure that the attorney that you're working with, if you're moving the case forward, is doing those things, and check with them. You have every right to talk to the attorney about moving the case forward and what they're doing to make that happen.
All right, Kelly, coming right back to you. The question is, I have a statement in my agreement that says only the parents can drive the children. My ex has her boyfriend driving the car for pickups with her in the car. Her attorney stated it doesn't matter because she's in the car. The statement doesn't say anything about being in the car, just that the other parent needs to be notified if someone else is transporting the children, and written consent must be given. Could this be considered contempt? It's happened 5 or 6 times there in South Carolina.
Wow. So yeah, I think that it really depends on the 4 corners. Attorneys like to say 4 corners of the document, right? So what does the actual language say? So as an attorney, we go in and we analyze what the language says, and legally, if that definition, if transport means somebody physically driving the car, then yes, she would be in violation if someone other than her is driving the vehicle. So it kind of, but if transport just means that they're in some type of vehicle that is moving, and it doesn't matter who's driving, then that's probably not an enforceable issue. So it really kind of comes down to what the decree says and what and what the law is based on that definition. And so there may be, and that's why you kind of need a consult on that. And you may even need to retain an attorney to research and decide and find out if there's case law. So one issue that we have in Texas that comes up all the time is we have invasive medical decision. Then that's usually a subject to agreement where non-invasive isn't. And there's there's case law all over the place, depending on what type of medical treatment it is as to whether it qualifies for invasive. So one of the ones that's sort of all over the place, depending on what jurisdiction you're is like, vaccines and vaccinations and medical. So, is an invasive something that punctures the skin or not? And that definition, there's different cases that hold that vaccinations do qualify and others that hold that they don't. So transport is one of those, I would imagine, is one of those types of issues where there may be some case law on file to determine what the definition in a final decree or an injunction is as to transport.
Yeah,
so you kind of have to look at that. But, yeah.
We have 3 offices in South Carolina. You can check it out. You can go to the website, cordellcordell.com. You can find out which office is nearest you or schedule online. Again, the consultation will certainly be more informative. All right, we're going to keep moving along. Jonathan, Kevin has a soon-to-be ex-wife, was the primary earner, about double what Kevin makes. We're about to have a finances, quote, discussion. She wants us to go at child expenses. They have 2, 50-50. We're in California, so I'd definitely be allowed child support. That's the question. Would he be? If so, I was thinking of just saying she should cover all the child expenses in lieu of a dollar amount of child support. I feel like going after child support will create vitriol and litigation, and I don't know if I have the energy to do that. Just want it to be over. Thoughts?
All right. Well, Kevin, kudos to you, first of all, in trying to avoid conflict. I mean, that is number one. When you're dealing with kids, really, I mean, looking 20 years down the road from today, I don't think your kids are going to go look back and say, gosh, if only dad had some more money from mom, my life would have been better. But for sure, they'll look back on life and say, gosh, I'm so glad my parents got along and didn't fight. I mean, that is a life changer for children. So if you were to try to put a dollar price on that, I'd say there is no dollar price. The ability to peacefully work out a divorce is priceless. So that, first of all, is a great intent. Now, looking at, the pros and cons of essentially deviating from the state guidelines and the support, I could probably spend an hour walking through those alone, because there is, incomes can always be changing, incomes can always be modifying. There's the concepts of even, the person who pays lots of times has a little bit more control over what they're paying for. And there's maybe some challenges in giving her all of that control. Maybe by just having the money, normal child support paid, then you both kind of can decide on what that money is being used for, as you each pay your half or proportion. But it's definitely an option. And courts love it when parents get creative and come up with something that works for them, because they'd much prefer you to work it out than to go and fight and have a judge have to make a ruling on it. So there is the pros and cons there. Each state does have different limitations and restrictions. So you will want to talk to your California attorneys. We've got a couple offices down there you could talk to. Because in Utah, if you deviate at all from what we could consider the guideline, you've got to do all kinds of just very clear explanation to the judge of why you're doing it and why this is best for your kids. Because the courts are very protective of child support. So you'll definitely want to meet with one of our attorneys and kind of walk through what boxes do we need to check. But I like where you're going with this. And I like the idea of, we really do want to avoid contention. And if it comes at a price, you're willing to do that. That's a good dad in you.
Yep. I have a little hesitation with leaving the child expenses so open. It's so subjective, and it's going to lead to an argument. I get it. I just think sometimes I'll live with whatever the calculation says rather than arguing over income. Quickly come to an agreement on what your incomes are, and then just fill out the form. That's quick. So anyway, Kevin, encourage you, go online, make a consultation. Kelly, real quickly, X came into a huge inheritance recently. This person pays a ton each month in spousal support. Can the spousal support be reviewed given her recent windfall?
In most cases, yes. In most cases, spousal maintenance is based on, as long as it's not based on a division of the marital estate. So if you have a spousal maintenance order that is really more like contractually based, or is looking to somehow adjust the division of the marital estate, then that may not be a reason for modification. But if you have spousal maintenance based on needs of your ex-wife, then absolutely, if she is getting an inheritance and she has now enough money to easily provide for her own support, most states will allow that modification to occur, and potentially look at termination. So you really, again, have to look at the terms of your decree and the law of your state. Is it a court-ordered maintenance award or support award that is based on her needs? And if so, then probably you can modify and terminate that. Most child support and alimony obligations are going to be court-ordered. And if they are, then they're going to be modifiable.
Mhm.
But that is something you absolutely want to check, because it's, and you're going to also want more information probably about her income and the inheritance and what she's getting from that. So that may take some discovery if you do file a modification or termination as well.
Yeah, I'd liken it to income is income, no matter what the source, and it impacts her ability to meet her own expenses. It could be a boyfriend, it could be a live-in, someone who's contributing towards the rent, the mortgage. The point is, whether it's inheritance or other lottery winnings, the point is she's now more capable of meeting her own reasonable needs and expenses, or a job. So yes, schedule a consult. I think it's worthy of a discussion. It sounds like it's worthy of a modification, but there's some other factors that need to be considered. All right, our final question, Jonathan. GAL, Guardian Ad Litem, on my case, has not talked to myself or my kids in over a year. They have trial in 2.5 weeks. The Guardian has done a home visit and talked to mom multiple times, but it's one intro call with me. My attorney hasn't been pushing the issue. The GAL is not recommending a change in the schedule. The GAL is clearly biased, to say the least. The question becomes, can I reach out to the kid's teacher from last year, who was never questioned about how the kids did in school with transitions?
Okay, a lot of questions here, and I know we're out of time, so I'm going to try to hit on a couple of just key points here. The first point, I'm a Guardian Ad Litem. I've been a Guardian Ad Litem for 13 years now. And I think the role of Guardian Ad Litem is very misunderstood by even the judges themselves. A Guardian Ad Litem is not a custody violator. A Guardian Ad Litem cannot provide testimony in court. They are an attorney who represents somebody, just like you have an attorney and your wife has an attorney. So the first thing is to be very aware of when you're going to trial is that this Guardian Ad Litem shouldn't be testifying to the judge. Instead, you're the one that can testify. And in part of your testimony, I definitely would make sure you tell the court, look, this is what I did, and this is the contact I've had with this person. But on the other side, the other spouse had a lot more and had a lot more influence. And I think calling teachers and calling other people to support your case is very important. There may not be just one teacher. There may be 6 or 7 people that you think might be very, very good evidence, because we don't want to rely on a guardian to try to summarize that testimony and just give a summary to the judge. You're going to want to put on your own testimony for sure. But it is tricky, and it looks like you could have had a situation where you didn't have as much information, and that's unfortunate.
Yeah. It's a lot of, I've had issues like this with guardians where they don't fully do their, duties and investigations and interview everyone we've asked and even our client, and push back. Your attorney needs to push hard and fight. And, it's oftentimes you walk into a courtroom and there are 2 tables, the petitioner and the respondent, or the plaintiff and the defendant. But where's the guardian sit? Interestingly, they wind up picking a side and they sit at one of those tables. Typically, there's not a third table. And it just, you can see that alignment. And so certainly don't accept it. I think you go ahead and fight it. You have to meet with your attorney and prepare and make sure, as Jonathan has indicated, that's something they shouldn't be testifying. And you're going to raise those issues to show that maybe ineffective and they didn't fulfill their duties. So any recommendations shouldn't be followed. All right. Well, thanks to the panel. I know that 30 minutes went very quickly. Thanks to everyone who joined. We'll do this again next month, where you have many questions, and hopefully we can give you direction and answers. So check out Cordell Cordell. If after today you think you have more questions, certainly go homepage, top right, schedule now, schedule a consultation. You can do that. You can search using your zip code. They'll find the office that's closest to you, and you can schedule right there on our website. Or you can find our offices, find the number, give us a call. You can call directly if you prefer as well. So check out the YouTube channel, check out our website, check out our social, and keep an eye out for next month in September. We're going to do the same thing. We'll talk a little bit more about different topics as well, but we know you have questions, and this is the avenue and the media to provide answers. So until next time, thanks for joining. Have a great rest of the week.